What's up, everybody? Welcome back in to our last day of testimony on Karen Reed's retrial. It's trial number 2. We got through Dr. Rentschler. We got through the rest of his direct, his entire cross, his redirect, and so many arguments. Today was an incredibly interesting day when it came to the decision making of the lawyers, the strategy of the lawyers, and how they handle witnesses, the demeanor of lawyers, and when they choose to push and apply pressure and not, and when lawyers will let things slide, and when it's time to stand up, say something to the judge, even if she doesn't want you to speak out in court because it has just gone too far. We'll talk about how to handle situations like those, what it comes off like to a jury, and we'll discuss what it means, the decisions that were made at the end of the day today, including Jackson pushing for more time in closing arguments. Make sure you guys hit that like button, please, if you have not already. Make sure every single one of you is subscribed to our page. Let's get to it. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested. Just kidding. That was the outro. Let's try the intro. That's what we wanted. That's what we were looking for. Starting off with a bang here. So today reminded me of how different a trial can look at the end versus at the beginning. And when lawyers are confident and you have a plan, and when that changes sometimes throughout trial, and sometimes they get a little less confident, sometimes that confidence can wane, sometimes it can be a roller coaster. Additionally, we're going to talk a lot about the strategy. Who are you calling? When are you calling them? And what are you going to do with each of these witnesses? And that can really change depending on how the testimony and the evidence is produced and presented to the jury. So today was a really good illustration of that. This was the last day. I did not expect today to be the last day. I know the defense expected to rest yesterday, and they did not. So they were a full day behind, which mostly arguments aided in that. But a really big decision by Hank Brennan to not even call Welcher. But we're gonna save that. I want to talk about that at the end when it comes in time. Let's first start with the rest of the direct examination of Welcher when he starts talking about the testing they did for this case. And what did he do for this trial that's different? We got his entire testimony basically from the last trial out pretty quickly, and he was up and down pretty quick last trial. Much more extensive testimony and testing and details, much stronger opinions and testimony this trial versus that trial. I cannot tell you. I've heard people say the defense never gets better in trial 2, which I disagreed with this specific defense team and this specific trial, because we can't forget they tried to continue the first case. Judge didn't let them. Prosecution tried to continue. Judge didn't let them either. I expected both sides to get better. I think that's what happened, but much more significant improvement on the defense side. Fine-tune their theory, their big picture, how they're going to look at it, and have time to prep a witness. Do you want to know the difference? When a witness, by the way, Brennan can say they were not independent, meaning Arca, the last trial, and that Arca was biased and Arca was a defense witness. He can do that all he wants. You guys should all be able to tell the difference between Russell and Arca when a defense team gets to actually prepare experts, because they didn't really get to prepare them last trial. Russell was kind of thrown in, and Arca was working for the feds. So the defense couldn't walk through everything with them. The defense couldn't say, can you guys do these tests? We want to know how much G-force it takes to break a bone. We want to know what it takes to break this taillight. Can you do examples and experiments and show us what can crack these taillights and explode these taillights at different speeds with Alexis? Can you guys do that? Yes, we can. And we can become even more confident in the theory we already knew. This is the difference when good defense lawyers get to prepare witness. You can call it coaching, call it whatever you want. The point is they're working together to say, how can we prove the theory you're telling us, Mr. Expert? And this is what it looks like. It's so different and it's so much better. And that is one of the main reasons why, because they were truly independent. That's what I was so shocked about. They were truly unbiased and independent. Now they work for the defense. And this is what it looks like. There's nothing wrong with that. Most experts do. That's why I was so shocked last trial that they were really from a third party. So he explains what he can do with testing and how he comes up with this hypothesis. He did in the very beginning throw out that it is his son Kai's 10th birthday. The judge was like, hey, stop. Shut that down. And frankly, I don't think that is relevant. I don't think that needs to come in. I don't think that was necessary. Would it bother me? No. It's humanizing him. Is it a big deal? No. Have other witnesses talked about personal stuff? Absolutely. Happy birthday to Kai, right? We can do that on this show. In court, do you need to do that? No. But a lot of lawyers and experts try to personalize and humanize themselves throughout the process. So it is what it is. And he decided to do that. Then he kind of explains the paint test. He explains what he does with what he looks at, what is important, what is not. Talks about superficial abrasions being very different from lacerations. Abrasions are much less severe than lacerations. He talks about there were no fractures to the right hand or arm. He looked at the x-rays himself, and he did that in his training and experience. He's done it before with surgeons, and he did that here. And he also talked about how important it is that if these x-rays exist, how you need to actually look at them. And maybe that's one of the reasons they don't want to recall Welcher as the Commonwealth, because he's going to get smoked on the fact that he was dead wrong about the x-rays existing. So let's take a listen here to a clip from Dr. Rentschler.
To determine what they represent and what injuries either did or didn't occur. You absolutely need to look at them.
Do you see any injuries represented or any defects represented in this x-ray of Mr. O'Keefe's right hand?
I do not, no, sir.
Can you describe what you do see or what you would expect to see if there were injuries, broken bones, torn ligaments, things of that nature, swelling? What would you expect to see?
You could actually see the fracture lines on the bones. They are evident along the hands or along the ulna and the radius. Any dislocations you see, there would be a difference in the space at the joints between the bones. Dislocation, then there would be an increased space or even a decreased space if there's compression of the joints, the interphalangeal joints, the metacarpophalangeal joints, the wrist joint. There's no indication on these x-rays of any fractures or any trauma or any type of injury to the bones or the joints.
Can we go to 229?
I mean, the length that he takes that to where it doesn't exist, and it's not just breaks, it's ligaments, it's joints, it's nothing that you would expect to see when a car that size going that fast hits you. I see some questions about the concert. I will talk about that at the very end of the video as to not bore the people that don't care and are just here for the meat and potatoes.
B is in Bravo with the court's permission.
Yes.
You see what's depicted in this photograph?
I can, yes, sir.
What is this?
So this is a x-ray of the forearm, shows the ulna and the radius, which are the two bones in the forearm.
Do you see any defects, injury, trauma to these bones or anything associated with those bones?
I do not. And when you're viewing this on the software to look at the x-rays, you can actually adjust the contrast. So you can adjust the brightness and the darkness, and it allows you to go through the whole range to better evaluate whether there are any fractures. This is a little bright, so when you're looking at this, you would actually decrease the contrast a little bit.
Yeah, because then you'd actually be able to see the bones if you did that. But he's just looking at it, showing how he can kind of take a look at it as well. Yes, happy birthday to Kai. We've said that. A bunch of the chats coming in here to wish Kai a happy birthday, because we can do that. It's my YouTube channel. I can wish somebody happy birthday if I want to. There's no judge telling me I can't. Okay, then they get to the sweatshirt, and I thought this was really interesting, and this is some of the stuff Brendan wanted to keep out. And he explained how it's important to look at the clothing and things like that, and he said 36 superficial abrasions on the arm, 36 different points of contact separately needed to come into contact with John O'Keefe's arm, only 9 defects in the right sleeve. Aperture never counted the number of abrasions or did any analysis like this. So what are those abrasions consistent or inconsistent with? Let's take a listen.
Of the number of abrasions, counting the number of abrasions on Mr. O'Keefe's arm?
There's no denotation, no indication that the number of abrasions were ever counted. No, sir.
Ultimately, based on your review of all of your testing, did you come to an opinion or a conclusion as to whether or not the abrasions on Mr. O'Keefe's arm are consistent with striking the right rear taillight of the Lexus?
I did, yes.
And what is that conclusion?
That they're inconsistent with striking the taillight or being produced as a result of contact with the taillight.
Why did you come?
No surprise. We knew that was going to be his answer. The fact that that is his answer and that is his opinion is not a surprise. Why? Why is that your opinion? And can you convince the jury that the science and the data back that up?
Come to that conclusion.
There's a number of reasons that I came to. First of all, the abrasions, the numbers don't correspond to the number of holes or...
Sustained.
Did you consider, without counting the number of abrasions and the number of holes, did you consider the abrasions?
I did, yes.
Did you consider the sweatshirt?
I did.
Was that an important part of your analysis?
It was, yes.
What else did you consider?
I considered that it was not possible to line up 36 different abrasions with...
So I'm going to strike that answer, ask it differently.
Your Honor, if he can finish his answer. He's about to say contact with the taillight.
Yep. So ask it differently, Mr. Jackson.
Sure. What did the 36 abrasions, conservatively, and their interaction with the taillight have to do with your ultimate opinion and conclusion?
Well, that you have to, if those abrasions came from contact with the taillight, you have to be able to correlate them and line them up with 36 different contacts from the taillight.
And ultimately, based on your understanding of Aperture's review and the photographs that you saw, you were presuming, based on Aperture's testing, that Mr. O'Keefe was wearing that hoodie. Is that correct?
Sustained.
What was the condition?
He gets into the fact that Aperture basically was just eyeballing it and drawing these yellow lines that he puts up here and saying this is about where it happened, but they didn't line up any of it. And they didn't do it for a reason because it's completely inconsistent with being hit with a shattering taillight. And he doesn't need to prove that it was a dog bite. He doesn't need to prove that it was a dog scratch, right? That's not what he's here to do. He's here to prove couldn't have happened from the taillight.
Paint extended on the surrogate's arm, say from the wrist up to where the laceration or the abrasions would have occurred.
Is that important?
That's very important.
Why?
Because you can't say that the area where the blue paint is corresponds to the area of the abrasions if you don't take measurements. If you just eyeball it, all you can say is by eyeballing it, it looks approximately the same. But that's not scientific. You can't come to an actual conclusion that where that paint covers the arm is where those abrasions actually were. They could lie outside, they could lie forward, they could lie above that painted area. You can't say with any scientific certainty that that area of paint corresponds to where the abrasions are.
In this motion video and the still photograph to the left,
Pretty simple, right? Like that's pretty simple. Eyeballing it is not scientific. Shocker, right? Big shocker there. They also get into the fact that the scratches, which is, again, this is a big common sense argument that everybody around the world has been talking about for the last couple of years. And that is that the way the scratches are going in kind of different directions doesn't make sense with a taillight coming across, scraping it the same way. And they've never answered that. Kevin, Peter, I swear I tried to look at it your way, trying to read right down the middle, but was hard to find anything positive from Cross after leaf blower haymaker. I did learn the defense is cheap, only an Uber/ham sandwich. Listen, we are probably going to do a poll at the end of the video today. Kelsey, remind me, what would you vote right now? Guilty or not guilty, or guilty of a lesser included? Because I think the evidence is done. It could still potentially change because Hank Brennan hasn't rested in front of the jury necessarily or said no rebuttal. So he could theoretically change his mind, but the evidence is closed. You don't have to be down the middle anymore. The jury's going to be voting soon. Is Hank allowed to argue dog DNA in closing? So if it just came out in his question, no, but I think Russell said, yes, she was aware that existed and she took it into account and she kind of explained how there are other reasons that could happen. So because she ratified it and talked about it, I believe he will be able to argue in closing. I would object to that if I was the defense and say it came in through his questions, Judge. It's not actually in evidence, so he shouldn't be allowed to argue that. I think the judge is going to let him argue it. Closing arguments tomorrow or legal work. Legal work, they're going to work on the jury instructions. So we may talk about some of those. If you guys have questions, hit me up on Instagram and Twitter with those questions because we're still going to do a video tomorrow talking about the jury instructions most likely. Defense choice to not mention x-rays was an absolutely brilliant booby trap. How often are lawyers handed such a gift? I mean, I don't know if I would say, I don't know. I kind of feel like if they would have smashed him on cross with it, it might have been just as good, if not better. But it's unusual for you to be handed a gift that big, but it does happen. It does happen. What's happening tomorrow? They're going to go through the jury instructions. Why would Bev say no? Okay, hold on. We're jumping ahead. I want to wait to talk about that. Can Hank Brennan play Karen Reed's interview clips in closing? Yes, they are in evidence. I think he'll play when Karen Reed says, I don't think I hit him. I think I could have clipped him. Did you hear Hank say those exact words to Dr. R today? Yes. And I definitely think he's going to play the Yannetti conversation that she does have culpability or liability, whatever he said. And to me, I'd play that at the end when I'm saying she's right. She does have culpability, vote guilty. So I definitely think those are going to be a big, big part of his closing. I'm so confused. Does Hank Brennan think being snarky is going to win over the jury? Is he doing it because he knows this witness was brilliant for the defense? We're going to talk a lot about Hank Brennan's demeanor when we get to cross-examination of this witness. So let's jump now to him talking about the kinematics not working for a taillight to cause these injuries.
Did you expect to see this pattern of injuries on Mr. O'Keefe's arm if, in fact, it contacted the taillight and if, in fact, it was abraded based on the taillight?
You would not. You can't get, for instance, horizontal abrasions on the upper arm and somehow get vertical and angled abrasions on the forearm. The kinematics don't work out to actually produce those types of injuries.
Can we go to the next slide, please? What are we looking at in this slide?
So again, this is the paint transfer test, and it demonstrates there were no measurements taken. So we don't know the exact size or location of that paint or the lacerations. And you can see the photograph on the right basically shows that after doing the test, a picture of the right arm was put next to it and basically eyeballed to say it's the same, well, it's only approximately the same area.
So I'm going to strike that. So next question.
Do you see any measurements, any tape measures, any laser measuring equipment, anything like that in that right photograph?
Nothing, no types of measurements whatsoever.
Can we go to the next slide, please? This is on the left, the same video that we've seen several times, correct?
That's correct.
What are we looking at on the photograph on the right?
So on the right, it is the video of this test taken from the side of the vehicle.
Did you notice anything of note in this angle of the paint transfer test?
I did. I slowed this video down. And so as you can see, as it starts out, and you'll see the vehicle starts to slowly back. So there was no photograph showing the position of the arm in the back of the car. The video is from the side, and the top video, you can't tell where the arm is positioned against the tailgate. But whatever positions it's at, you can see as the car backs up here, look at the elbow and the upper arm. If the car backed directly in this direction, there would be no contact with that elbow or the upper arm. And remember, this test is to show where the paint would transfer and if that correlates to the lacerations.
You mean before you start the video, when you say there would be no contact with the elbow or the upper arm, you mean the biceps area and from the elbow up?
That's correct.
Is that based on the photograph on the right and the positioning of the surrogate?
Exactly. You can see right now if the car just backed directly straight back.
What he's explaining is, and he used words like Welcher jammed his arm there, or you shoot your arm forward, that Welcher made sure to move in a way that would put the arm to line up with the taillight. And I agree. I think he's crushing this test by Welcher, but I get what Welcher was doing. He's showing the jury a theory that if the taillight hit the arm, it's possible that it would scratch it in this area. I think he only did one test when he should have done a bunch of different tests to show that this is likely. And this is my testimony to a reasonable degree of scientific certainty. The problem was he couldn't. So I get what he was trying to do. But man, when you compare it with what ARCA did, Porsche, $400K for one test, proving nothing thoughts, it was a really embarrassing moment on cross again when Hank Brennan rights aren't wrong. Why would Brennan say for 90 minutes? Oh, sorry. Gosh. There's a question in here that I will put up. Oh, here we go. I feel like Hank Brennan was trying to discredit Rentschler by saying that he didn't know the position of John O'Keefe and how he was hit, when he was hit, discredited his own witness and his entire case. Yes, his own cross is explaining why Welcher and Aperture fell woefully short of proving anything beyond a reasonable doubt, which is in fact Hank Brennan and the Commonwealth's job in this case. It's like he forgets. I don't actually think he forgot. I think he's won cases this way, so he's using that MO. That just doesn't seem like a way you can win or should win as a prosecutor.
Back, it would not contact the elbow or the upper arm.
Before you play the video, what did you note when the car from the angle to the right of the video on the right? What did you note as the car, just before the car starts to make contact with the surrogate? What did you note?
So in order to get that pattern on the arm, right as the car contacts the arm, the surrogate pushes his elbow forward, leans into the car against the light, and then rolls off.
Can you play that for us, please? Did you see what you were describing in that video?
I did, and I can slow it down. So you can see even at this point, as the car approaches, it would not contact the elbow or the biceps. So as it comes in, watch the elbow all of a sudden shoot in. Surrogate turns his arm in and then leans against the light cover. So this is not indicative of someone standing there and having a car back into their arm. In order to get that pattern of paint on the arm, someone would have to stand there, and as the car approached and contacted the arm, they would have to actually push their arm forward and lean into it to get that paint pattern.
Is that, in your view, proper scientific testing?
Sustained.
Let's move to the next slide.
All right. We're going to jump ahead a little bit here. 134.
Abrasions, all it does is just say, under this specific condition, if someone was to stand there and then shoot your elbow forward and lean in, you would get paint on this approximate part of your arm, because we don't even have any measurements for it. That's the only thing that test demonstrates, and that's the only test that was conducted to look at the interaction between the arm and the Lexus in this case.
Did you reach any opinions and conclusions regarding whether the physical evidence is consistent or inconsistent with the injuries to Mr. O'Keefe's right arm?
I did, yes.
And what are what's the basis?
The
for those
basis
opinions?
is looking at the number of laceration or the number of abrasions on the arm, as well as the orientation and direction of those abrasions. And they don't correspond to how the arm would interact with the vehicle if it was at a right angle and struck by the rear of that vehicle.
Do you hold that opinion to a reasonable degree of scientific certainty, Doctor?
I do, yes, sir.
Can we move to the next slide, please?
Pretty strong.
Actually, slide 33. Let me have just a moment, Your Honor.
Yes.
Included, did any of the testing that you saw in terms of the paint transfer test or any other testing that you saw included in the Aperture report and the Aperture PowerPoint presentation indicate that there was any consistency or any results that were consistent with Mr. O'Keefe's right arm being struck by the taillight, causing 36 plus abrasions to his right arm while wearing the shirt, the sweatshirt with 9 holes in it?
That's sustained. You have to ask that differently, Mr. Jackson.
Did you determine, based on the testing by Aperture, whether or not it was consistent, that paint transfer test was consistent with Mr. O'Keefe's arm being damaged by the taillight at speed?
I did.
Okay, and what is that conclusion?
That does not represent that at all. The evidence from that test, again, is it's only puts paint on the arm. So in no way does that determine or demonstrate how, if the arm struck the taillight cover, how the taillight cover could shatter, how the movement of the arm could interact with the cover to produce those abrasions.
Did you go, I'm sorry.
There's just no evidence of that. There's no steps taken to demonstrate how, if that's even possible, would that actually occur in a case like that? First, you have to show it's possible. I saw no peer-reviewed articles, no research data, and the only test that was done that links the injuries to the taillight cover is this paint test.
Is that the paint
I
testing?
mean, that's about as much as you can smash someone else's testimony. And he smashed it so much. And now we have the context of knowing Hank Brennan is not even going to call Welcher back. And we'll talk about what I think about that when we get there. But that's about as much as you can smash a test. And he agrees. That test shows there is a way you can line the elbow up with the height and distance with the taillight. But that's all it shows. And it's important to talk about what a test or experiment does show and what it doesn't show. It doesn't show that you could break the taillight. It doesn't show that there's enough force to break the taillight, not break the arm. And right after this, he goes into there was definitely enough G-force or whatever to break the hand, break the arm, bust up the ligaments. That seems so commonsensical and makes so much sense that when you watch the crash test dummy, when you hear them talk about this case, it's like, yeah, obviously it makes sense that there's enough here to break bones and cause very serious musculoskeletal injuries.
I do, yes.
Okay, it's basically now broken. Is that correct?
That's correct. It has now been fractured, yes.
All right, let's go one more frame forward. And the taillight material, did you make note of that in this frame?
I did, yes.
What direction is that taillight material going relative to the vehicle?
I thought this was so good. Like so good. Look at where the taillight's going. How is that scratching his arm the way that it scratched, the way that the scratches end up on his arm? I just don't get that. They did such a good job of creating a visual for the jury as to how impossible this is. Sure, somebody can get hit by being reversed. They can get hit in the arm. They can get hit in the body. Of course that can happen. It can happen with a drunk driver. It can happen in Boston. But it would look so different than it looks here.
It's going forward.
And where is the arm?
The arm has been pushed away. Now, you have to remember, as that arm, if it contacts and fractures the taillight, it's not exposed to the fractured pieces that still exist on the taillight itself, because those pieces that fracture haven't gone anywhere because they're against the arm itself. And then as the arm moves away, the pieces then move with the vehicle.
Are the taillight pieces upon fracture moving at the same speed as the arm upon contact?
That's correct, yes.
Is that a matter of physics?
That is a matter of physics,
Is
yes.
there any possible way for the broken pieces of taillight to out-accelerate the arm upon contact, and the arm's being deflected away from the vehicle?
It is not, I don't believe it's physically possible. That was not demonstrated in our testing, and I've never seen that demonstrated in any peer-reviewed articles. Now, you can see here again also the light and the fragments are being propelled forward. So you also have to consider where Mr. O'Keefe was found. He was found in the yard about 10 or 20 feet from the road. There was no exact measurements. But if you look at the
Brennan like really hammers that. He's like, you said 10 or 20 feet. Details matter, don't they, Dr. Rentschler? Was it 10 feet? Was it 20 feet? Did you not know we have these measurements and those measurements? It's like, not sure what that's doing to rebut all of the issues he explained about the lack of broken bones and how the taillight couldn't cause those abrasions, but he's trying to find the details he can disagree with.
Motion of the taillight, it's going forward. Now, if Mr. O'Keefe has to move diagonally to the top left of that corner, and if he's not hit with the center of mass, he can't get to where he ends up before the taillight fragments have already gone forward and been deposited on the ground. Average running speed is like 4 to 6 miles an hour. Even if this SUV is going 10 miles an hour, the lights fracture, they're dispersed on the ground, and then Mr. O'Keefe somehow ends up to his point of rest. But you wouldn't find the fragments on him because they've already been pushed forward, come to rest before he even has a chance to get to where they find him.
Let's go.
That's what's so important about explaining, all this scientific stuff that, hopefully for the defense's sake doesn't go over the jury's head. But it's like, that's why you explain how quickly everything's moving. Because if you explain how quickly it's moving, you realize how it's really impossible to end up exactly where it ended up. And the damage done to the body in the car to end up that way just doesn't make sense, doesn't fit. And by the way, that test we just watched, he's like, yeah, there were no defects in the sleeve from that test because he didn't get road rash. He didn't drag across the street. He just got hit and smashed the taillight, which didn't cut up or put puncture holes into the sweater. He says it makes no sense in this case because basically the Commonwealth's theory would be John O'Keefe could have been hit by this car, this Lexus going 24 miles an hour in reverse in the arm. And if the taillight wouldn't have shattered, we would notice no injuries on John O'Keefe's body anywhere except for the back of his head, obviously from falling down on the ground. Does that make any sense that you can get smashed by a car and you'd never know it unless the taillight happened to break and scratch your arm? Zero evidence he was hit center mass. But what about a glancing blow, right? Because I think even the prosecutors at this point agree it wasn't center mass. But what does he say about a glancing blow?
Into your ribs, into your torso. You would have very significant and substantial loading to your body.
Or he's ending his answer about center mass first.
Initially the right side of your body as that impact occurred, and there's no evidence whatsoever that occurred.
Switching to a glancing blow, a blow of just the arm, not the center of mass, but just the arm. You hold an opinion and a conclusion as to whether or not a glancing blow or a blow to the arm only.
If this is true and John O'Rourke would vote not guilty right now, that's a bad sign for the Commonwealth. I'll just say. I don't know if it's true. I didn't see that in the chat. I don't know if it's true, John. I'm not going to put words in your mouth. But if you are, that is a bad sign for the Commonwealth.
Would propel Mr. O'Keefe 7, 8, or 10 feet perpendicular to the line of travel of the vehicle.
I do.
What is that?
It would not be possible. Our testing demonstrates that. Peer-reviewed articles demonstrate that. I've seen no evidence.
It's not possible. Yikes. CJ, hit me up on Facebook then. I got Facebook too.
Anywhere in this case that would suggest or even indicate that if you get a glancing blow or a sideswipe blow, that somehow would produce enough force to push you 8 to 10 feet into the yard. I don't believe it's possible. I've seen no research that would indicate that would occur.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please? And let's go to the next slide. Let's keep going. Okay. What are we looking at in this slide?
So this slide, it's a paper that describes.
All right. So that was the glancing blow that he said was not possible. And then he goes into lower extremity injuries. There were no lower extremity injuries. Talked about 3 cadaver subjects that were struck at 20 miles an hour or something. They had significant lower body injuries, not just one small minor abrasion / bruise. Welcher cited one article, and it's from 1979, and it says head injuries are the most common body part injured in cases. And that article, interestingly enough, came out before the first modern day SUV came out in 1984, which I didn't know that's when it came out, but that's very interesting. And now it very clearly is lower body injuries from all the research and articles. Now, Welcher used the same 50% dummy for the drop test. Drop test is showing what happens when somebody falls straight back on concrete. Isn't that interesting? Kinematics don't work by getting hit by the SUV and propelled backwards onto your head. And then we get kind of his final opinion before direct is over here. So this is kind of the end of direct.
Opinion to a reasonable degree of scientific certainty.
I do, yes.
Can we go to the next slide, please? May I have just a moment, Your Honor?
Yes.
Finally, Dr. Rentschler, do you have an opinion, or did you reach a conclusion whether the biomechanical evidence in this matter is consistent or inconsistent with Mr. O'Keefe's right arm being impacted by the subject 2021 Lexus 570, resulting in a backward fall leading to the head injuries that he suffered?
I did, yes.
And what is that opinion?
My opinion is that the evidence is inconsistent with Mr. O'Keefe being struck on the right arm by the SUV and then moving laterally into the yard and falling backward onto.
And do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Thank you. That's all I have, Your Honor.
Okay.
That's the end of direct. I'm sure Hank has seen the online sentiment and been told, what's your thoughts on him getting more aggressive? Does he not care he's turning off the jury? So let me tell you about most lawyers, okay? But I do think lawyers are learning, okay? Based on my experience last Friday, speaking at the FACDL, the Florida Association of Criminal Defense Lawyers, I do think even older, board-certified, good trial lawyers are learning. But generally speaking, and I'll just throw myself in there, we lawyers think we know best. There are big egos, especially if we've had some success in the courtroom. We think we know our own style. We're going to do it our way. So some lawyers would double down, go further into the way they do it. And maybe that's all I can kind of guess as to why he continues to go in, and more thoughts on this with some of the other questions. Why did Hank object to the number of abrasions, and why did the judge tell him to strike that statement? I'd have to listen to it specifically to talk about why he struck it, because he was absolutely allowed to get into 36. But if there were some details around it, I'd have to hear the exact question and answer to tell you why. Confused as to the taillight fragments found on John O'Keefe's hoodie. Does the jury know about it? And was it debunked by the defense? So that's been testified to. Hank Brennan's asked it to like a million different people. It is, to me, clear it came out in evidence that they say they scraped that and the taillight, or the pieces, the debris matched the taillight. What the defense has done is Proctor gathered it. It was put in a bag with all other debris. It was put on the hospital floor. It was cross-contaminated with a million things. There's no chain of custody. So how reliable actually is that? That's what the defense has argued. Sorry if you've already answered. What is a charge conference? Thanks for your awesome shows. A charge conference with the judge and the lawyers get together. They go through the final jury instructions. Are there objections? Do you want this in? Do you want this out? We come up with a final form, and that's what the judge is going to read to the jury on Friday. Peter, do you honestly think Hank really believes Karen Reed hit John O'Keefe's? I have to say yes to this. I have to say I think he believes it, but I don't know. I felt like Hank Brennan was fishing for a mistrial with some of his cross questions, planting evidence, in my opinion, thoughts. So I will say, and this is going to come out again, we're about to talk about his cross, and I'm going to talk a lot more about his demeanor and the decisions he made. He is not acting like most good prosecutors would act. He is not being careful to protect a guilty verdict. He feels like he's fighting more like a criminal defense lawyer. And I don't just mean leading witnesses or poking holes or reasonable doubt. I'm going to dig into that a lot more about what exactly he's doing that is so much more like a criminal defense attorney, and why it is so dangerous for a prosecutor to do it, and much more unethical for a prosecutor to act this way than a criminal defense attorney. And anybody that wants to disagree with me about that, I'd love to discuss it with you. Thanks for all your recaps during the testimony. Quick question. Are there ever times when not objecting is more beneficial than objecting? Absolutely. Or is this truly a one-of-one case? No, absolutely. If it's going to be good for you, even if it's inadmissible, they ask it, let it come in. Peter, don't you think the most baffling part of Hank's cross was insistence that Welcher never made claims regarding the position of the arm? It's hard for me to pick the most baffling part. I know it's been a while since you talked about this, but did you hear Baldoni's entire case was dismissed by the judge? I've only seen headlines. I can't comment on it because I haven't read the actual documents, and that can get me in trouble. So I'll wait to comment more on that, but I will be talking about it. Octavio, lawyer, love your channel. If found guilty, what are her chances of successful appeal? Better than average. Still not great, but better than average, I would say. Don't you think not calling Welcher because he hurt him so much in his cross of the defense witnesses? I've got a lot of thoughts on why he might not call Welcher. I would like to know why you prosecuted that case. Oh, the one that I did. So it was like the third trial I ever had. They handed me the case. They said, go win it. And I went and won it. After that, and after being on the criminal defense side, I learned, which is why I give people grace. I've been in their shoes. I know what it's like to try to go win, especially early on in your career, or you're building your career. I know exactly what it's like. The reason I did it, well, I also didn't realize they didn't fit till literally the middle of trial, where they're making an argument and I use definitions and words and try to twist my way to get there. That's what I did. And I convinced the judge, I convinced the jury. I wouldn't do it today, but at the time I was like, I got to go win this. My boss gave me this case. I'm a young prosecutor. I want to go try to win it. That's what happened. That's the honest answer. Peter, will you tell us today? At the time, I absolutely believed it did. Looking back on it now, I shouldn't have done it. Peter, will you tell us today if you believe Karen Reed is guilty or guilty? or is not guilty or guilty. I'm going to wait till after we do the poll, but I've said it plenty. Just seen Karen Reed supporters holding love signs, but silent. It brought tears to my eyes. I feel strong. She was framed. Hank Brennan really confuses me. It sounded like he was saying Welcher, and therefore the Commonwealth is not alleging this was the Lexus hit John O'Keefe. And since they aren't saying that, they basically aren't giving any idea of how this happened. So we're going to get into that right now, exactly how confusing some of this cross was by Hank Brennan and whether or not his demeanor was successful. Facts matter, don't they, Dr. Welcher? Yes. You don't know where he landed. You don't know where the impact was. This 10 to 20 foot estimate is wrong. He's like, did you talk about Welcher's testimony with anybody? Anybody tell you to try to get ahead with that 50% dummy issue instead of the one that's closer in size to John O'Keefe? And then he does something I find preposterous. I don't understand how the judge allows it, because what he's saying is not even really true, number one. And number two, this is something that the judge has said cannot come in the case because it's going to confuse the jury, yet she allows him to make these arguments. Let's take a listen.
The weight of the body, but I'm not sure what he would have made adjustments for.
When you look at the ratio, force and mass, and that changes the testimony about the 50% dummy, had that,
In this case?
yes,
Yes, sir.
and you knew there was a sequestration order before, hadn't you? Had that issue been raised with you?
No, sir, it had not.
You had testified before, hadn't you?
In this case?
Yes,
Yes, sir.
and you knew there was a sequestration order?
Prior?
Yes.
Yeah, I didn't discuss the case with anyone, no, sir.
Well, you didn't discuss with anybody, you said?
I did not know.
Before you testified last year, you were receiving information from your employer about issues and testimony in the case.
The party that retained us told us things. I didn't break any sequestration. They were the ones in contact with the court. So it was my assumption that whatever they were telling me was allowed by the court.
How good of an answer is that, by the way? He's like, the person that hired me was talking to the court, and it was between them and the court. It, to me, is totally unbelievable that Judge Cannoni would do this, because she's going to let this hurt Karen Reed when it has nothing to do with Karen Reed, and she knows darn well that that's the case. Karen Reed had no control over what the FBI was going to share with Rentschler before he was testifying. And she's allowing them to do this under the guides to hurt Karen Reed. It's not relevant to Karen Reed. And she can say, I guess the way it's coming in is Rentschler's credibility, but that's totally unfair without the context of the FBI being involved, which she is initially, I felt, rightfully keeping out of the case. But to have it used here in a way that definitely looks nefarious, but not you. So this is a way to hurt the defense with it. Again, sword and shield, to hurt the defense with it. But the defense doesn't get helped with it, saying the FBI hired you because they wanted to know if John O'Keefe was hit by a car. You told them that he wasn't hit by a car. To not allow that in is mind-boggling. And to me, somebody asked about appeal, a major appellate issue, that she allowed Hank Brennan to dance around this and use it, but not get hurt by it.
They were the client. I didn't discuss anything with them or tell them anything, but yes, they told us certain things.
Before you testified under oath last year, you were getting updates from your employer about details of this case, weren't you?
Maybe we can approach briefly.
So they approach, and we're going to talk about these approaches in a second as well.
Before you testified last year, you were receiving information, not from the defense, from your employer, about other witnesses' testimony during
So now he's making sure he's saying not the defense, but his employer, but they were sharing testimony with him.
the event, weren't you?
I don't know if they told us about witness testimony. They told us about certain evidence. I had no contact with the court, with the prosecution, with the defense. I had no idea what was going on. We were retained by a certain organization, and they contacted the court. They were in talks with the court about, I guess, what we could or couldn't do. Anything I got was from that organization.
I do like that he keeps saying that it was between them and the court. Nobody's going to say he's wrong. Nobody's going to call the FBI and tell him in here to say, what were you guys doing? Why did you do it? What'd you tell him? Why'd you tell him?
Fourth,
So he's going to try to impeach him here. It doesn't really go well. He impeaches him a little bit later, but again, it sounds like he keeps saying the same thing over and over again. I don't think this was a very successful impeachment.
the event that I was not aware of.
I don't know. They told us about evidence. I don't know if it was specific to who testified to what, but they told us certain things, certainly, yes.
What I just said to you, are those your words, sir?
I have no idea. I mean, if that's what's in the record, I assume it is.
Would you agree it certainly helped you prepare?
It helped me prepare.
Yes.
It didn't make a difference to my analysis or conclusions.
Made no difference at all?
It did not, no, sir.
So you notice how he said it made no difference to my analysis or conclusions? Because the help me prepare is what he gets impeached on. And I think he may say, no, it didn't really help me prepare whatever. If he was impeached on anything, it was that. And listen here, Lisa, how could the Commonwealth have paid $400,000 for Aperture's work? I'm going to push back on all the comments saying that Aperture was the biggest waste of money for the Commonwealth in this case, okay? I think you guys are dead wrong. And let me see if I can convince you. Do you remember Dr. Crosby? Cosby or Crosby? I can never remember. The dog bite expert? They paid him $1. It was too much because that dude didn't even end up testifying. He was so not helpful that they didn't even call him at all. At least Aperture sent 2 people down there to testify for multiple days each. And they did at least one test. And the jury heard about it. What did Crosby give you?
Agree it helps you understand what was going on during the trial?
I don't think it made a difference at all. No, it doesn't change the facts that I evaluated or the analysis I conducted or the conclusions I came to.
And so as you sit here today, you are denying that that information certainly helped you prepare.
How did it help me prepare? It didn't change the opinions I offered. It didn't change what was in my report or what I'm opining to or testifying to today. It hasn't changed anything I've ever testified to.
I'm going to ask you a very specific question. I want you to give me a very specific
Objection, Your Honor.
So just go ahead and ask the question.
Are you denying that receiving that information certainly helped you prepare?
Honestly, I can't remember. It did.
The amount of time that he took on this was like, dude, you needed to do something better. You needed to do something better with it.
Understanding of the trial.
Ahead a little bit, by the way.
With the defense, didn't you?
I think I had like 2 phone conversations, 2 or 3.
So that sounds like a yes, you did.
Yes, there was one right before my qualifications, my voir dire, where I talked to Mr. Jackson, and that was it. Other than that, I think it was just planning and scheduling.
Was there any discussion on how you could portray yourself as independent?
I don't believe there was.
You don't believe.
No, there was no need to.
That's not the question. Details matter. Was there any attempt?
So the objection is
All right, so we're going to start mentioning now the comments that we've been talking about that Hank Brennan continues to make. His, either wind-ups or testimony or making comments or saying things that have nothing to do with the question, talking to the witness, mocking the witness, being disrespectful to the witness. And we're going to show some of them. We're not even going to show all of them because there were so many today. But details matter. Well, you're the one who said details matter. Well, do those details not matter? Before he asks a question, I guess you choose which details matter and which ones don't. Things like that. Totally inappropriate. Jackson objects. The judge is not controlling Hank Brennan. She is not controlling this courtroom the way that she should control the courtroom. And when she doesn't, Jackson has enough. And he's like, you know what, Judge? If it's a free-for-all, then I'm going to start swinging too. And he absolutely starts swinging back to shut Hank Brennan down, which is exactly what you have to do as a lawyer. I don't care if it annoys the judge at this point because it's happening in front of the jury.
sustained. I'm going to strike that, folks. Okay. Questions, Mr. Brennan?
Was there any attempt in your conversations to portray yourself as independent? As far as your arrangements were concerned and coming out here?
No, I don't think so because there was no need to because it was independent.
When you had conversations with the defense,
He's like, I didn't need to portray it as defendant or as independent because I was independent.
did they offer to give you transportation assistance getting here?
They provided a ride to and from the airport, yes.
Did you tell the defense that you prefer to take an Uber so that it would appear independent to a jury?
No, because I didn't take an Uber. I took the ride. If I wanted to appear independent, then I would have taken an Uber.
Did you have a conversation about it?
It's so weird that Brennan's asking these questions. It makes me think that he has some information that says this, but he doesn't push him on it. He's like, yeah, that's a good idea. Maybe I should have taken an Uber if I really wanted to look independent, but I didn't care. So I didn't take an Uber.
That you were thinking about taking an Uber.
It didn't even cross my mind, sir.
And then after you testified, did you say independent?
What do you mean independent?
Well, did you have any bias warning you?
Any bias?
Bias. Yes.
What do you mean? Did I have any bias?
Well, after you testified, where did you go?
These vague, bad questions, he's eating them. He's eating them. He's like, come on, bring it. It's like, what do you mean by bias? What is your definition of bias? No, I'm not biased. I don't care if somebody's paying me. I'm not biased. No expert witness is going to admit that if I get paid now, I'm biased. No, you can argue I'm biased. I am not.
Well, I was waiting for my ride, and to get back to the airport, they had to take other people. And so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride will take you to the airport. So I went, and I had a ham sandwich.
You had a ham sandwich. Did you testify at some point that after you had
That repeating of you had a ham sandwich, like sarcastically mocking witnesses. People may think it's funny online. People may think it's cool. Even if Alan Jackson did it, you guys might be like, you just shouldn't do that. And you know that from day one that you shouldn't do it. And that's important. Knowingly, intentionally saying things in open court that you know you shouldn't say. They're inappropriate and inadmissible. That's where lawyers can really get in trouble. Peter, I'm just coming in, but the thing all day, you might have answered this before, but can Cannoni reprimand Brennan for speaking the way he did to Jackson? I mean, not just how he spoke to Jackson, but how he is questioning these witnesses. Absolutely, she could and should admonish him. Tell him, if it happens again, there will be sanctions. If it happens again, I will admonish you in front of the jury. She should definitely do it first at sidebar or outside the presence of the jury. But if he keeps doing it, which he did after probably private admonishment, she needs to do it publicly, and there needs to be more teeth to it. He does it over and over again. And it's not even about like respect for the witness or candor or being nice or a nice guy or a mean guy. It's nothing to do with that. It's what's happening in front of the jury that could be prejudicial, and that is not relevant and should not come in at trial. That's the most important thing that's protected for the criminal defendant. And at some point, they're going to have an argument that is intentional prosecutorial misconduct. I'll just tell you right now, I'm trying to give Brennan every benefit of the doubt. I always have. Ashley asked me a question of, giving a grade to each side this trial, which I will. My grade would have been probably shockingly high to a lot of you after the Commonwealth's case in chief, but it has continued to drop after this cross-examination. And I would absolutely argue this is prosecutorial misconduct if I was the defense attorney. This would piss me off to no end if Hank Brennan continuously questioned witnesses this way when he knows he shouldn't be able to. He knows he shouldn't do it like that. Cannoni knows it because she sustains all these objections and strikes all those comments. But at some point, when you know it's coming and he's done it for 31 days, there's got to be more.
had something to eat, you just stood in the corner?
I did. I sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
When you sat at the table and eat, did you just eat your ham sandwich, or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Certainly, I'm sure I did, sir.
Did you laugh along?
I assume if something funny was said, I probably laughed.
Did you talk about it?
He answered these questions great. I have seen good experts struggle with questions like this because they're so dumb and you're like, what are you talking about? What's the big deal? I ate a ham sandwich. Yes, I sat over there. I don't know if I laughed. I guess I could have laughed. A lot of experts don't know what to do with those types of questions because, I don't know. Maybe he thought Hank Brennan was going to ask him about the abrasions, about the injuries to John O'Keefe's arm or the lack thereof. Maybe he thought he was going to ask him about stuff relevant to the case.
Testimony?
At this point, I don't even remember.
Let me alert you to something. When you were there at the luncheon, did you see a camera crew
I believe I did. Yes, sir.
filming and documenting, right?
There were a lot of cameras. Yes.
You know that you might have been on some of that footage?
That's fine. I could care less.
Okay. So do you think maybe you were talking about the case?
No, it's not great, to be on footage and documentaries and whatever, but it doesn't mean he's biased, number one. Number two, if it was really that bad, the jury probably thinks, why didn't you play it?
Your answers and laughing it up a little bit?
I have no idea. Possibly.
You were involved in conversations with the defense attorneys, were you?
What do you mean conversation, sir? I had just gotten done testifying. I was having lunch. Whatever was spoken about at the table, I'm sure I heard.
You know what a conversation is when someone speaks to you and you answer.
Sure.
Did you have conversations with some of these folks?
Sir, I can't remember conversations I had last week, let alone a year ago. So I probably did, but I have no clue
Do you remember any,
what we would have talked about.
do you remember accolades you might have been receiving because you had given certain answers to the then prosecutor on the case and laughing about the answers?
I have no idea.
Remember?
I can't remember last week what I had for lunch last Tuesday. How would I remember a conversation from over a year ago?
You remember when you were
Would have been like, but you remember you had a ham sandwich, right? You don't remember last Tuesday, but you remember that ham sandwich, right? I thought that was coming from Hank Brennan.
conversations with some of these folks and You were laughing about when the prosecutor asked you about other evidence like DNA. You had a response, well, the physics doesn't change. You remember?
I don't specifically remember that, no, sir.
How long were you at the table eating your ham sandwich with the folks there enjoying the event? How long do you think that went on for?
I
Enjoying the event. Like,
honestly don't know. 10 minutes? How long does it take you to eat a ham sandwich? 10 minutes?
And after you finished your ham sandwich and then you told us you stood in the corner, you got a ride back to the airport?
I did, yes, sir.
After you got back to the airport, ultimately your company billed the defense for your time.
so then they get into, yes, I bill. I don't know how much. I get paid salary. I don't know how much Aperture was paid. It was the same case number as when we were billing that other entity, which anytime you could talk about that, I think that's pretty effective for the defense. Then they get to the text messages. He's like, I think I deleted 2. Don't use Signal. Never use Signal. Don't know what other people in my company use. He handled those questions impeccably. I thought Brendan didn't do any damage at all to him with regards to those questions. Again, Hank Brennan, details matter. I know you want to be detailed, making comments like that nonstop. One good point I did think Brendan made was all his peer-reviewed articles were 20 years old when he was from grad school, or in grad school, and they're all about wheelchairs. Now, Rentschler did talk about how that is relevant and how it moves with the kinematics and the way bodies move and things like that. And he did a good job of making them relevant. But I thought, I'm looking for some good things Brendan did. I thought that was actually pretty good. Looked at Wolf's report, relied on each other for different things. Then they get into, are you making medical diagnoses? He goes, I don't make medical diagnoses. And RRT says, what if a juror says they know it was FBI and deliberations? I mean, if they're saying they figured it out or they surmised, that's one thing. If they said they went and looked it up, that's another thing. That's a problem. He talks about how, I don't make those diagnoses. Those diagnoses were made by the medical professionals in this case. That's not great. So Hank Brennan is making all of these comments. He is ad-libbing and winding up in a situation, and this is where I'm going to tell you the difference between a defense attorney and a prosecutor. Defense attorneys sometimes will do this. Defense attorneys sometimes will try to play on the jury if they're with them, really get the jury to hate the other side or love their client. They'll make some snarky remarks. They'll do this stuff. They'll battle with the witness. They'll toe the line. They'll go all the way up to the line about what's appropriate and what's not. You want to know why? Because if they win, it doesn't matter. If they win, it's like it's over. No judge is going to be like, unless you are really egregious, no judge is going to overturn a verdict because a criminal defense attorney did something like this. But in civil cases, and even more importantly than that, prosecutors have to be more careful. Good prosecutors are way more careful. They do not want to be the reason there is an appeal and an overturned guilty verdict. And they happen for this very reason. I am very careful as a civil plaintiff's attorney now. I was very careful as a prosecutor as well when I prosecuted cases not to do things like this. God forbid, because I've also read appellate decisions where the judge has overturned a civil multi-million, hundreds of millions of dollars in a civil class action lawsuit by one of the best plaintiff's lawyers I've ever seen. And I've watched him give presentations because he was too snarky and disrespectful during the trial. He went overboard, smashing witnesses and commenting on the other lawyer. So it can happen. And it's making me think at this point, Hank Brennan doesn't care about an appeal. He's like, if I win now, I can move on. I did my job. If it gets appealed, that's the next guy's problem. That's what it's starting to feel like with Hank Brennan. Throwing caution to the wind, actually not starting to feel like, that's what it's felt like the entire defense case in chief. Throw caution to the wind. Ask about dog DNA, even though it never actually came out in evidence. And I'm not going to call rebuttal evidence to get it in anyway. So he did not cure that problem. I said Hank Brennan could cure that appellate problem. He chose not to. So now if the appellate court's like, that should have never come in, well, you don't have the issue that it was cured later. I bet you the defense appellate attorney's like, ooh, that's a major issue now. But it seems like he doesn't care. He wants to win. And this stuff is rising to the level of being significantly problematic. And we're going to jump and just watch one of those moments together.
It breaks differently.
Well, sure. I mean, the testing we've done here, the taillights covers fractured differently, and we didn't get any contact. So I have personal experience just with this case alone.
We'll
sir.
get to the contact. When you look at all the tests she did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
I didn't ask you that. Is that funny?
It's not funny.
Okay.
So
He didn't even laugh. He like kind of smirked. He didn't even laugh.
Didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
I didn't ask you that. Is that funny?
It's not funny.
Okay.
So I'm going to strike the comment. Next question. Next question, Mr. Brennan. No more comment.
Do you notice how Jackson is now speaking up more in front of the jury? And he does it immediately after Brennan says something snarky. And he's right. And he's highlighting it for the jury so they see it and they see he's pissed off. And they then hear the judge saying, no more comments, sustained, strike that. Incredibly important for the jury to hear all of that in that sequence.
When you did your experiments, the sizes of plastic that broke were different in each experiment, weren't they?
They were, yes.
The number of breaks in each experiment were different, weren't they?
They were, yes.
The angles of the break changed from piece to piece, experiment to experiment, didn't they?
I'm sure they did.
Did you watch the videos and watch the damage and take a look and count how many pieces broke in each experiment?
I didn't specifically count. No, we looked at contact to the sleeve and to the dummy itself.
You never counted the broken pieces in each experiment?
I did not. There was no need to.
Not matter if there's a need, did you?
I did not. No, sir.
You had talked quite a bit about Dr. Welcher's test with the paint, so I want to ask you some questions about that. Were you ever under the impression that Mr. Welcher, you can take that down, please. Were you ever under the impression that Dr. Welcher was trying to reenact the actual collision when he did that blue test?
Now is where Hank Brennan is going to decide to nuke his own case.
I'm going to allow it.
Well, that was the only test he performed, and he referenced that test for his opinion that the position and orientation of the lacerations are consistent with the taillight cover. So if that test was not intended to signify or demonstrate the position of the arm, he has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
If his test didn't demonstrate that, he did nothing. His testimony was completely worthless.
Now that you've shared your opinions, can I get back to my question?
Sustained. So, Mr. Jackson, Mr. Brent, I'm going to see counsel at sidebar.
I want to be like, woo, 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 because I hate that. And it would be vice versa. I feel the same.
So, Mr. Jackson,
Jackson's not shutting up. He's not sitting down, Judge. He says in front of the jury, I want him to be admonished. And then the judge brings them up. She doesn't admonish him in front of the jury. I think she should have, but she does sustain the objection, tell the jury to disregard things, strike it when he says stuff like that. So it's very clear that Jackson is winning on these points, and the jury picks up on that. And that's exactly what you have to do, especially when you have a judge that's not helping you out.
Mr. Brent, I'm going to see counsel at sidebar.
I'm going to skip this sidebar. Or was this? Oh, this is this sidebar. So a lot of people are asking, he keeps repeating questions. Why is Brennan allowed to ask these questions over and over again? He will argue, and my guess is Judge Cannoni would agree, that his questions are not being answered. So they're not asked and answered because he's saying something else as opposed to answering my question, or he'll throw in, which Jackson does as well. Let me ask it this way. And sometimes that's a different question. Therefore, that specific question might not have been asked and answered. We have the lunch break and then we're back. And he talks again about, the soft tissue and, whether or not it moves this way or that way, ligaments versus bones. He gets into the fact that MRIs show soft tissue injuries better than x-rays, which is what we talked about the other day. And he's right, but it's like they don't usually MRI the entire body, in case you were wondering. X-ray they do, not MRI. I also liked how when Brennan would twist something in his question, Rentschler would push back and be like, hey, you've completely misrepresented what I did, what I said, and what my testing is. And I'm glad he did that, because if you can't just let him get away with, any lawyer get away with twisting what you said, you have to know what you said and push back when they try to put words in your mouth. We're at the 1 hour mark, but we're not done. So for some overtime here, everybody take a second, hit that like button. A third of the people that watch every one of these videos don't subscribe. I don't know why. Hit that subscribe button. It would help us out. We'd love it. So if you wouldn't mind, subscribe, like it. Let's get to a big chunk of Brennan's back and forth here about what did Dr. Welcher actually prove? And as some of the questions have come through the chat, did Brennan nuke his own case?
Shouldn't be used in that manner. That's why I don't use it in that manner.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit, do you?
Well, the evidence I have for that is that in his report, he says that the orientation and position of the lacerations are consistent with the orientation position of the taillight cover. And then right under that, he has reference to that test that he performed. So again, if he didn't intend to do that, then there's no evidence that he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the taillight cover. If it doesn't,
Just like the Commonwealth being like, where did you get 24 miles an hour? Where did you get that she backed up to him and he was standing like this with his arm bent? Where did you get that? We never said the data said that. Where'd you get that? It's like they think being intentionally vague is like smart or some kind of trick when it's exactly the opposite. And once again, they're not saying it was 24 miles an hour. They're not saying he was standing like Judson Welcher. They're not saying it happened exactly like they did in their video. So what are they saying? What do they think they've actually proven? To me, an appellate court might look at this case and be like, no reasonable juror could find Karen Read guilty with how some of this evidence is being argued by the Commonwealth. Do you think the jury noticed Hank was soft-spoken with Dr. La Posada and so aggressive with Dr. Rentschler? He said, regurgitated so many times, not guilty 100 or 1,000%. I think the more noticeable difference was when Dr. La Posada was on the stand, because this feels more like Hank Brennan's MO, how he acted with this witness.
represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was hit by Alexis?
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that. And again, that's the only test that he's performed or referred to in this case.
You inferred that.
Inferred that that's how he believes that the arm was positioned.
I think we understand your perspective is that the only test he performed, but what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welcher represent that?
I mean, you're making me sound stupid because I'm assuming that his test showed that the taillight could hit this part of the arm because that's where the paint was. And you're acting like I'm stupid, but I don't get it. I don't understand what you're saying. Why else would he have done the test? Can you tell me why he did the test? Like, if you're on the jury, you have to be sitting there like, what's Brennan talking about?
And he was trying to describe the actual body position of John O'Keefe when he was hit.
Actually, he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video
Just gives Rentschler so many opportunities to smash Welcher, and he takes them.
of his arm like that and contacting it. And then he holds his arm up to a picture of Mr. O'Keefe's right arm to compare and apparently demonstrate that it's in the same area. But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose. But if it's not, again, then I'm not sure what that test actually accomplished
Well,
or
I'm asking
represented.
you. You've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the taillight cover. If it doesn't represent that, you're right. I changed my opinion that there's
And Brennan may think that's a win to have him say, well, if I was wrong about what Welcher thinks, then I changed my opinion. But he can't be wrong about what Welcher thinks in that test, or that test proved literally nothing. It proved next to nothing now, but it would prove literally nothing if it wasn't even used to show the body positioning, which Brennan repeats multiple times that test was not supposed to be a reenactment.
There's no evidence, no analysis, no conclusion whatsoever.
I'm going to try to make my question a little clearer. Is there anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by Alexis?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Welcher, anything, that states Dr. Welcher was stating or claiming that he knew the body position of John O'Keefe when he was struck?
I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident.
You
You're
know
correct.
whether Dr. Welcher has been clear that he does not know? Let me say this differently. You would agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown.
Here he goes. He goes in with the specifics that Welcher didn't put any specifics in his report, did he? Because we don't know anything. And we didn't prove anything, sir, did we?
After being in a collision.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that actually occurred. That's the basis. Yeah.
He's like, that's what I'm trying to say, Hank. Thank you, sir. He's like, yeah, you're right. You can't actually prove that occurred.
Replicate a collision with crash test dummies to
Crazy.
a reasonable degree of scientific certainty.
Well, you're right. You can't prove that actually occurred. That's the basis. Yeah.
He's like, I thought that's what I was supposed to say, but he's like, you, sir, can't prove what actually occurred. That's why that was a huge point to me.
So,
If you don't have
You
the
can-
information, you can't replicate what happened. You can't determine, you can't say to any
Could have just stopped because he had already given the great answer, but then he kind of helps Brendan out a little.
conclusion of accuracy what actually occurred if you don't have the evidence.
so if you were to do a
If you don't have the evidence, why don't we have the evidence? Because of the investigation.
crash reenactment, but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision, that wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
I mean, I don't know if Brennan realizes how much he's smashing his case every time he says something like that, but Brennan's point of his questions are completely flat because he's acting like you can't do any tests. But that's not what ARCA's saying. ARCA, both witnesses are saying you cannot prove every specific detail about what happened to John O'Keefe, but you can prove what it takes to smash a taillight. You can prove what it takes to hit somebody to where they land on the back of their head. You can prove what it takes to scratch somebody's arm, break bones, break the skin, bruise it. You can do tests to prove those things. So while sure, we can't reenact exactly how the accident happened, proving those details and facts, that's the point of accident reconstructionists. I'm actually going to jump ahead a little bit here.
And in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Other than your opinion, let's get back to my question if I could.
I believe I answered at the beginning of that, sir.
I'm going to ask you again. My detailed
So many of those, so many of those.
question is, there is nothing in Dr. Welcher's report or any of his
Eddie looks like he's holding in a smile there. I didn't see this when I was listening to it earlier, but it literally looks like he's literally looking at the jury and looking like he's trying to hold in a smile. I'm starting to get the feeling that tides may be turning there in that courtroom. And Hank Brennan, I'm like anxious here because it's like, if you're Hank Brennan, and you're turning off the jury and you can't stop yourself. Like as a lawyer, that feeling would just crush me if I was in that zone and I was like, I'm going to keep hammering away. And it's like you're digging a hole deeper and deeper. That makes you anxious as a lawyer. But if you're the other lawyer, like Yannetti, you love it.
Any of his presentation that states he is trying to represent the exact posture, movement, and stance of Mr. O'Keefe when there was a collision. It's not anywhere in there where he stated that.
It's not stated. I'd be curious to find out what that, if that wasn't the intent of the test, I'd be curious to see what the actual intent was.
Is the answer no, it's not in there?
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again, is the answer no?
The answer is no.
When you do
It just looks so bad as lawyer, especially because he actually is answering them. He's explaining his answer, but he is answering them. Nicholas, why would have Welcher have cosplayed J.O. if he didn't intend to represent his position? So you ever have like a friend or somebody you know where they're like, well, I know something, but I can't tell you how I know. It's like, well, I know something, but I can't tell you this. I can't tell you what it is, but I know the answer. Like my son used to do that when he was young. He's like, oh, I know the answer to that, Dad. I just can't tell you what the answer is. It's like, well, that's not helpful. And you're not proving to me that you actually know the answer. That's what it feels like they've done multiple times in this case.
do crash tests, you have a controlled environment in some respects, don't you?
You do, yes, sir.
You get to control some or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
I suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, doctor?
I don't know, is it?
What I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases, you said. Have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And if you want to conclude that something happened and this is how it occurred, you have to look at those variables. If you can't control for those variables, then it's possible you can't prove that it actually happened. So yes, if you're doing a certain test to prove.
You notice how all of his answers are like, then you can't prove what actually happened. Let's listen to one more quick cutoff, and then I'm going to answer a bunch of questions, and we'll jump back to the testimony.
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no, you don't need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of an
Exhibit
individual.
73, please.
Literally cuts him off in the middle of his question. Bob, I agree. I think Rentschler was a great choice as a last witness for the defense in this trial. I think he was so important to the number one question in this case. And I mean, great for the defense that it's the last. I want to try to hold my thoughts on rebuttal as much as I can, but this is the last witness the jury's going to hear for a day off and then closing arguments. Pita, the Commonwealth submitted their jury instructions on the 2nd. Are you able to get those and go over those with the chat? Totes, dig your lives. If I do, it'll be tomorrow. I have not seen them. If somebody has them, shoot me an email. Send them to me, please. Do you think Welcher said, F no, I'm not coming back? I doubt it. He'll probably cash that check, Did Aperture bow out to protect their brand? I think people think what they think about Aperture at this point. Do you think the defense must explain how the taillight and glass end up at the scene, Proctor? I think they've inferred that plenty, and witnesses have said it, kind of like this witness is going to say it, and so they're going to be able to argue that in closing. Didn't the Commonwealth's ME testify no x-rays? If not, then why wouldn't anyone hear about them? I do not think the ME did. I think Welcher did. How have you seen the jury react to a lawyer like Hank Brennan? I've never seen them react positively. They usually hate him. And I'll just say, I have seen my dad go hard at people and attack witnesses on cross and hit them really hard and sometimes be jerky on cross. And sometimes that can be effective as a defense attorney. It's a lot less effective as a prosecutor, number one. Number two, it's been in trials that we've lost. And while we haven't talked to the jury after some of those, I think it could have been negatively impacted as well. And like I've said, I've been sarcastic sometimes in cross in cases. And I haven't talked to every single juror in every single case that I tried, but I'm sure that's turned off some witnesses. So you have to just be careful. In closing, can the defense talk about Karen Read interview clips and say they were taken out of context or anything like that? I think they can absolutely say they were taken out of context, but they're not going to be able to say, here's what she said right after. Not going to be able to do that. Hi, Peter. My fiance Kathleen pointed me to your channel and loves watching your videos. I thoroughly enjoy your down to earth manner and watch all of your videos too. Thank you for your work. Peter, do you wonder the jury will be surprised not to hear from Karen, as she, unlike most defendants, has been so high profile in defense? I'm sure there are jurors that want to hear from her, but I think the interviews, at least some of them will think, okay, we did hear from her a little bit at least. Do you think the Commonwealth's no rebuttal witnesses? Oh gosh, so many questions about that. Do you think, and I'm going to answer them all. I'm going to answer them all when we get there. Do you think they will make the jury instructions in the verdict form very clear given what happened last trial? I do. Or do you think they will let it ride like last time? I think it'll be different. I worry Bev goes about it the same way. Peter, did you notice HB used two experts, Wolf and Welcher? These names are so close to Wolf and Rentschler. You think this was for confusion? I did notice that. I don't think it was on purpose. Why was Brennan always allowed to ask hypothetical questions that have nothing to do with this case? Also, what kind of admonishment could be given? Members of the jury, you should not consider anything a lawyer says, their opinions, their statements. It's questions only, and the lawyers have been instructed not to do that. That's the admonishment she should have given in front of the jury at some point. Peter, Rentschler was great as the last witness for Karen Read, pushed back against Hank Brennan when needed. Do you think it's enough? Is it the smart money on another hung jury? Shout out to my friends, now your subscriber, Tower of Power. Here's what I'll say. I think he was a great witness. I think he pushed hard any juror that maybe would have been on the fence into the not guilty camp. We'll talk about what the best bet is, I guess you could say. Kelsey, why don't we go ahead and throw up the poll now? Guilty, not guilty, or guilty of a lesser included. And it's not perfect, and we'll get more into specific charges later. Peter, can you shout out my friend Rashida? Her and I are getting members of our club onto Lawyer You Know one by one. Do you think Dr. R took it too far with his combativeness with HB? How will it affect the jury? I thought he kept a pretty kind demeanor, and he was kind of jovial almost because he's doing his job. I don't think so, but you guys can tell me. Do Greg, count the number of times Brennan said details matter with cross the Rentschler after asking details matter, right, sir? I agree. It was not effective in my opinion. Yeah, lesser included and hung jury. So guilty, not guilty, lesser included, hung jury, 4 options, Kelsey. Ashley D, rate overall performance for Commonwealth and defendant for each trial. Lally, I thought was just a nice smooth 5. I would say Hank Brennan is probably a 6.5. I would have had him much higher after the Commonwealth's case in chief. I think the defense has been a 9.2, maybe over a 9, I would say, for the defense overall. Am I the only one that thought Brennan was running the prosecution version of Chewbacca defense? This seems to be a pattern what the defense is doing, indicative to me that the defense is very aware the Commonwealth has crumbled. No, it could be. So if they do closings on Friday, will the jury start their deliberations or will they push to Monday? What are the pros, cons of each? So we're going to talk about how long closings are. They're not going to be all day. So I think the jury is going to get the case Friday. I find it funny Hank yammering about details matter, but misstating the facts matter and had to be corrected. Not very detail oriented, are you, Hank? Do you think Handkerchief decided not to put on a rebuttal case? Okay, we'll hold that one. Details matter. What about the ham sandwich? Did you get a Coke or a Pepsi? Hey, Peter, just joined. Did you enjoy your concert last night? Yes, I loved it. And I'm going to talk about it more at the end. Peter, as a fellow Greek, who do you think are the best looking people in the world? And why is it the Greeks? Spoken like a true Greek. Do you think many objections by Hank wears on the jury? Maybe, but he's winning a lot of them because there are a lot of leading questions by Jackson. He's a defense attorney, so it happens and it's normal. Peter, what percentage of cases are won or lost on closing arguments? Do they affect the outcome or are they performative formalities? So more cases are won in openings than closings. Closings are more about arming the jurors that are on your side and with you to go back there and fight for a not guilty verdict or a guilty verdict if you're the prosecutor. Closing arguments are giving them those pieces of evidence that make them stand strong, don't switch over, and bring people with you. That's really what closings are. Did Chloe ever come in? I don't remember them mentioning anything about the dog just bites. They did mention Chloe. Chris K was here, then had to leave for a call back. Thanks. Any chance for Lori Vallow and Brian Koberger update? I will try to do those at some point. Yes. How can Hank Brennan use the FBI against ARCA, open the door? From my perspective, if he could have opened the door, he would have. It seems like Canoni is not going to allow him to open the door. Post rest, do you still consider the battle of the experts? And please explain. For me, prosecution didn't prove, so not guilty. Definitely see clarity after or for the jury after last 2. I think the battle of the experts was won significantly by the defense. Why did they not call the daughter, Allie, to testify as she indicated that John was in the house? I don't think she did. I don't think she indicated that. if the Commonwealth doesn't bring in dog DNA witness to submit to the lab, then can't use it in closing argument, correct? They can use it if Dr. Russell confirmed that she saw that there was no dog DNA and she took that into consideration with her analysis. I think she did, but I'm not positive. If she did, I would argue that is in evidence. Does the number of mistrials as well as the amount of issues during this trial make it more likely melt because something can be recused? I don't know what you're asking. I don't think Cannoni's going to be recused, if that's what this is asking. Sorry if this has been asked. How many times can this case be a mistrial? There's not usually a number limit on retrials. Is there a limit on how many times you can do it? No. Usually it gets thrown out in the interest of justice later, not now. It could be retried. Don't you think Hank Brennan trying to gaslight the jury, thinking all he has to do is show possibilities that Karen Read hit him, intentionally shifting the burden? I don't know if the jury picks up on that, but he has fallen woefully short of proving his case. Preliminary reports on the poll, 88% not guilty, 2% guilty, 3% lesser included, 7% hung jury. And we will see how that changes as the video goes on. Let's continue to listen to a little more of Dr. Rentschler's cross. I think today might be a little bit of a longer video.
Report about reviewing those.
It says I reviewed medical records and could put it there. I mean, there's a number of different possibilities.
That's the photograph?
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Right. Is one of those ways being in a collision with a Lexus?
I suppose that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to when or how a hat may appear in a yard.
Who do you think put it?
Here we go. Could have been put there. And Hank Brennan, I mean, to me, just not a good, this does not help you to ask this question.
Could put it there. I mean, there's a number of different possibilities as to when or how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that what we're getting at, sir? By the way, the x-rays.
Totally inappropriate. Totally inappropriate once again. So Jackson keeps objecting, keeps wanting to go to sidebar. Hank Brennan's like, I'd rather change the way I said it or change the form than go to another sidebar. Eventually, Judge Cannoni begrudgingly allows him to come to sidebar, and Jackson wins. And that ending is so important because they're all trying to make it obvious to the jury that Jackson's wasting your time. He's calling for these sidebars when Jackson's doing exactly what he should. And then he ends up winning, which shows he was right to push for those sidebars. And it's inappropriate. It's inappropriate again. Nobody seems to care. Nobody cares about private defense attorneys that make a lot of money, right? Nobody feels bad for them, but it's wrong. And it's not how it should happen. All right. Let me see the next clip here.
Level of superficial abrasions along the entire arm of minimal depth of less than 0.5 millimeter through impact with the glass. To have that minimal force on every part of the arm to only cause superficial abrasions would be highly unlikely.
Do you think some of those sharp pieces, if they were lodged in Mr. O'Keefe's sweater, could cause an abrasion?
It's possible if you had enough punctures and holes
By
in
the
the
way, a lot of the objections here were Hank Brennan was saying glass or plastic pieces, and Jackson's like, there was no glass in there.
sweater to correspond with the abrasions on the arm. That would be, I suppose, that could be a possibility.
Oh, same thing with like the nose. He was saying glass or plastic. He's like, it was glass. It was not plastic. Nobody said it was plastic. Karen Read's statement. Yes, usually the defense does need to arrest in front of the jury. I didn't see them do it in front of the jury, but everybody was reporting they arrested. So I don't know if that's going to happen later. You think the FBI will be involved again after today? I don't know.
In your testing, not to belabor it, I'm just going to show you one. I want to show you video E. Could we go to video E, please?
I'm going to jump ahead a little bit.
Stumble backwards after being hit.
I'm going to allow that.
What do you mean by backwards? Because you'd be spinning. So what direction is backwards?
Could a person get their foot caught on a curb, sneaker come off, and then stagger backwards and fall on their head?
I'm going to allow that.
Doctor?
she's letting Jackson say beyond the scope and things like that, reasons for his objection. I actually don't think this is beyond the scope.
Can you answer that?
I mean, I guess you could somehow predict or have a possibility of almost anything happening. You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that. So it's just supposition, but I won't say it's impossible.
You think John O'Keefe did somersaults into the front yard of 34th Fairview? Is that what you're telling us, Doctor?
No, I don't think he even got hit by the car, sir.
That's not what I'm asking.
Well, you asked I hate to be disrespectful, but it's like, if you ask stupid questions, you might get stupid answers. And Hank Brennan is mocking another witness, repeating his answer back as if his witness didn't say a spaceship, that went up into the air or whatever. And after he mocks him, he kind of snaps right back at him with a very good answer for the defense. Yeah, he's like, I mean, sir, you're asking me all these things. The car didn't hit him. So you're giving me all these examples that I'm scientifically certain didn't happen.
You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that. So it's just supposition, but I won't say it's impossible.
You think John O'Keefe did somersaults into the front yard of 34th Fairview? Is that what you're telling us, Doctor?
No, I don't think he even got hit by the car, sir.
That's not what I'm asking. I've heard that. I'm asking
Yeah.
if he did somersaults into the front yard.
No, there's no evidence of what he did.
Your Honor, come sidebar quickly before I start.
Okay.
All right, we're going to jump to after this sidebar. He does try to impeach him a little bit with that testimony, so we'll listen to that real quick. Actually, I don't really care. It wasn't that effective. I'm going to skip to the redirect. It's kind of in the beginning of his redirect. But he does end. It is important to note that he ends impeaching him about, yes, people were talking to him about the case and he did consider it. And it was, kind of impeaching him about whether or not it affected his, testimony or helped him. It didn't affect his conclusions or his testing, but did it help him? That's what he impeached him on. But this is how Jackson starts the redirect.
Yeah, inquired.
Yes.
Thank you. Dr. Rentschler, you were just asked a couple of questions about they provided information about the prior
There was a point where he said it wasn't, I'll speak slower for you, where again, he was not going to get pushed around by Brennan. The witness said, I'll speak slower.
trial, correct? They provided information about the prior trial, correct?
Correct.
They is no one associated with the defense team, correct?
That's correct. No one associated with you. And they provided information. And again, it let me know what was going on, but it didn't affect my preparation or my opinions. It in no way changed any of my opinions or what I testified to.
Thank you for
To,
that.
to get through this, I'm going to let you just
Thank you.
answer the question.
Sorry,
And-
Ron.
Rachel.
And with-
It's like, I basically want you to lead so that you don't say FBI, because it would make so much sense if you said FBI, because we're talking about the FBI and we're trying to call it everything else but the FBI. But we're trying to give as clear of a picture as we can. So that's why she's basically letting Jackson lead, and she's trying to tell the witness, just answer yes or no. Don't give too much information.
with regard to, and I appreciate that. Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer, actually? The actual employer that you work for?
ARCA.
Okay.
You got to be very careful. Very careful. Don't say FBI.
Wasn't them.
No,
It was a client, correct?
it was a client.
A
That's
completely
correct.
separate entity that hired you for that work, correct?
That's correct, yes.
Thank you. Thank you. You were asked about a fender vault collision, and you said, well, this wasn't a fender vault, right?
Correct.
What is a fender vault?
A fender vault is when you're hit by the front of a car and you're moving across the car. So you're moving across the center towards the driver's side of the car, and the car hits you. You go up over the car and you fly over the fender to the driver's side of the car. So you vault over top of the fender.
Dr. Richler, where is my, as I stand here, where is my center of mass?
Right about your belly button.
Right there.
Yes.
So what would happen if I was hit by a vehicle, front collision, and the vehicle struck me below my center of mass?
It's going to flip you. Your center of mass will go. You'd go right up. If it was coming right at you and it hit you at your legs, you'd flip right into the hood or over top of the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the fender.
Did that set of circumstances, physics, have anything to do with your analysis in this case?
No, none whatsoever. The profile of the car is completely different. The back of the SUV.
You were asked several questions about the debris field in the test F as in Foxtrot. Well, actually, you were asked about both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F, the full rear impact, center of mass impact, correct?
Correct.
You were shown several photographs, exhibits of very tiny, tiny shards. Do you remember that?
I do, yes.
I'll get to that in a second. You're also shown some photographs of pieces of plastic that were claimed to have been found at 34 Fairview. Clear plastic, piece of red plastic, correct?
That's correct, yes.
In your review of all the data in this case, do you know when those pieces of plastic got to 34 Fairview?
I do not. No.
Do you know?
Could be important. And this is when he's pointing out, they did so much better of a job. And I was begging for this after the first trial. Just pepper in the planting and the dirty cops and the third party culprit and the conspiracy. Just sprinkle that in to give the jury. It's like, I guess maybe that happened because it really doesn't seem like a car accident happened. And they've done that beautifully. They've done that beautifully without making the jury feel like they have to decide that all these people were involved in a huge cover up. And that was really important for trial number 2. And they did a really good job of it.
How those pieces of plastic got to 34 Fairview?
I do not know.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Who put them there? As if somebody did put them there, right? Is that something that has to happen? C. Hicks said, do you know what happened to the juror from the first trial? Joined the defense team week 1. She could be helping and working in the background. I don't know, though. Hoping you'll run a poll for me. What do people perceive worse? A defense lawyer defending someone they think probably did it, or a prosecutor prosecuting somebody they think probably didn't do it? This is an easy one for me. Kelsey, why don't you save this? Maybe we'll do it as a poll on another video. Okay, this is the Commonwealth expert witness, the woman in the hat talking about phone data, had an issue in a past case that Canoni wouldn't let in. What is the difference between what Dr. L? Why was the past allowed in? She didn't allow that past case in either with Dr. L. Why did the FBI hire ARCA, or are they FBI agents? No, they hired them in to investigate the investigation in this case. Did the defense say they were motion to dismiss tomorrow? If so, is that normal? And what do you think it will say? Yes, it's normal in every single case. They will do it. They will lose. Holly, I'm nervous a young jury may focus on the cause of death and reasonable doubt instead of reasonable doubt. How do you think the defense could make this clear to the jury before they deliberate during closing arguments? You have to focus on it. You have to focus on what reasonable doubt is. Can the defense tell the jury the DA could have called Welcher back to defend his report, but they didn't? No, that would be a bridge too far. JBW, how do you think the doc handled Brennan Smart in terms of Doc's look to the jury? Do you have any concern the doc displayed too much bias toward the defense when saying no car hit John O'Keefe or other comments? To me, I don't think he did, but you guys tell me. What was your read on it? I don't think he did. Prosecution's case was stronger than number 1, but so was the defense's. I agree. This time, though, the prosecution looks like they're hiding things. If the jury, number 1, taught us likability is key, the problem for the state. Thoughts? I agree. And I didn't grade the defense on trial number 1. I probably would have said 8.1. Low 8s, trial number 1. Low 9s, trial number 2. Be really hard for me to ever give somebody a 10, right? There's no perfection, especially in a long trial. Is it possible Hank Brennan got called to the principal's office during the lunch break? No. Highly doubtful. My jaw dropped during this part of the cross. I was like, he's seriously continuing down this line of questioning. He didn't realize what he was doing. I feel like that. Does the defense have to file a motion about the DNA in order for it to go on appeal later? This trial was insane. Can't wait for the movie. No, they've protected the record in their objection. Katie, didn't the judge rule dog DNA could be questioned because the prosecution was going to bring it up in rebuttal? No, she said because Dr. Russell considered it, read it, knew about it. That's why he could ask about it. Is this objectionable burden shifting? Brennan's line of questioning, you can't put a doubt in our theory if we don't have a theory, has stunned me. Sidebar, Peter, how was the concert? Loved Whitney and your outfit last night. It was awesome. Blissful comment. Jackson objected, facts not evidence. Judge said he was standing there, but there's no evidence he was standing there. Thoughts? Well, I think Nagel could have argued somebody was standing outside the car, but I don't remember this specifically, and I always hate to really give too deep of an answer if I don't remember something specifically coming out this way. Not sure Hank Brennan was what he was trying to prove. The Commonwealth theory is not 24 miles where it happened. What are they even saying at all? I agree. That's my problem. Peter, longtime lurker. My question is, if HB has to lie and twist evidence like we've seen, how could he possibly continue to try this case in the name of justice? And what about the O'Keefe family? I would say he doesn't think he's lying and twisting things. Does the jury know that there was a rebuttal witness? No, they never will know that. If Karen Read is truly innocent, what is your opinion on how O'Keefe died? I have no idea. I really don't know. I shouldn't say I have no idea. I don't know. I don't have a confident answer. Something balls can defend motion to have this open court. I don't know the answer to that, or I don't know what you're asking. Why was Hank allowed to ask things outside the doctor's scope, but when AJ did it, it was outside due to his scope? Hank Brennan wasn't necessarily asking him things outside his scope. He was basically saying, you didn't look at this stuff, so you can't come up with the answer. And he's like, that's not my job. Experts have to answer questions like that all the time. Can Bev and Hank get into trouble for what happened during this case? Theoretically, yes. Do I think it's actually going to happen? No. Are there any updates regarding the missing witness motion? I haven't seen it if there are. Are the clips of Karen Read in evidence? If so, is the full segment or full documentary just the clips used? I believe just the clips used. That's all I saw was entered into evidence, and that's all that can be used. This is a garbage case, but Hank Brennan is skilled. What do you think happened to this case? Ego, pressure, the end of this recross felt like he accepted defeat. Somebody said they saw like text messages where she admitted she was guilty, and that's why they really want to do it. I don't know. What did the judge rule on missing witness? I haven't seen. If Karen Read is found not guilty on all charges, how does this affect the civil case the O'Keefes have against her? It would not automatically throw it out. It's different burdens, a much lower burden in the civil trial. Do you think 60 minutes is long enough for closing? Alan wants more. Bev won't allow it. I think 60 minutes is woefully short, and we're going to watch Alan Jackson's argument for that. Do you think maybe Brennan is tanking the case so he can blame the Commonwealth for the loss because he was given an impossible case? No, he knew the case he was taking. Hi, Peter, big fan. Brennan asked about how the lights on the snow in the hat. O'Keefe was found literally lying under the snow. The hat was found under the snow. The broken lights were found on top of the snow. Not guilty to me. What is the missing witness motion? I've only heard you talk about it. When will it be addressed in court? It hasn't been addressed in court yet. They're trying to argue the Commonwealth could have called Proctor, Higgins, Albert, and didn't, and it should have a negative inference for them. Can we get a poll on how many are factually innocent? We'll save that when the jury is deliberating and we're discussing what they could be saying. Why is the footage of Karen backing into John's car not used more to explain how the taillight was broken? I don't know if the defense is really confident in proving that. They didn't really talk about it much with the ARCA experts. Poll on who thought guilty, now innocent. Another poll we can save. Anything else picturing Bugs Bunny and Elmer Fudd during this exchange? Brennan's talking himself into getting into to the boiling pot. Thank you again, Peter, for the dailies. I'm really enjoying the weeklies with Papa also. Yeah, I can't wait to talk to him this week. I really think that Brennan threw his expert under the bus. Do you agree? I do. I'm a silent watcher and love your lives. I think not guilty. Do you think a younger jury would dismiss butt dials? My 20-something said, kids, it's not a thing with smartphones. They actually laughed and said, it's a Nokia thing, old people. How many times does he need to hear him say, I don't think it was a car accident. A car accident didn't happen before he stops questioning him about it. Peter, if it's a hung jury, do you think the Commonwealth will try Miss Read for a third time? I tend to think they would, but oh boy. If Koberger is pushed, can you look at the Pam Hupp case? I don't know anything about it, so hard for me to answer that. Hank said he will bring in the dog DNA evidence in rebuttal when the defense asked for a mistrial. Now he's not doing it. Is that an issue? That is not the reason the judge allowed it from my memory. If Hank tries any shenanigans during closing, can Bev shut it down? The defense object, yes, but will it happen? We'll see. Is Brennan going straight to closing arguments without rebuttal witnesses? His Thanos moment, fine, I'll do it myself. I don't know. Okay. Let's listen to a little bit more of this redirect and then a little bit of the recross, and then we'll be done here soon.
Were you aware in your review of the police reports that none of the plastic that you were shown was found at the time John O'Keefe's body was discovered and the area was initially searched?
That is correct. Yes, I was aware of that.
You indicated that the cut on Mr. O'Keefe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, if they're claiming the abrasions are a result of the fractured taillight, it has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by the person. And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't come out and then make a right turn and then somehow embed itself on the left side of the nose. That's
Anytime he can bring up something that makes so much common sense, you want him to do it. He's like, that doesn't make sense. Let me jump ahead a little.
What's his name?
In your opinion, were any of the injuries that you saw suffered by John O'Keefe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
Thank you.
And then he gets in his final opinion again. Hank Brennan gets up and says, okay, so it wasn't a vault a collision, but it could have been, or vault flip, whatever it's called, but it could have been a side swipe. And he's like, no. Then he starts talking about the leaf blower, which again, I thought was not great for Brennan.
Near Mr. O'Keefe's body. Do you know the limits of the search?
By the way, he's going to go into like, oh, it was so hard for the cops. They were so limited. Do you know about that? I don't think anybody's really buying that. Like that because it was snowing, they didn't have to do a good investigation.
That the Canton Police Department did around Mr. O'Keefe's body, how small of an area they searched when they first went there?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
I don't think she admitted to it, right? But if they think it's a confession, then obviously I think those are going to be big. Sri, therapist here, asked about his behavior awareness earlier. I have no doubt of his extremely low insight thoughts. I don't know. Some people just don't care.
I'd have to go back and look. I don't recall specifically.
And so when there was a snowblower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Okay. Did you notice in the injuries to Mr.
Rats.
O'Keefe, most of them are on the right side of his body?
Well, we have the abrasions and then a 0.5 centimeter abrasion. And then we have the laceration and stuff on the left side. And then the skull fracture, it's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the 0.5 centimeter. It's not a bruise. It's a 0.5 centimeter abrasion, about an eighth of an inch.
When you're conducting an investigation or you're doing your analysis and you keep saying the physics, do you add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all of the evidence, right?
It's not just, we don't want the jury to just consider the accident reconstruction and the physics, right? We want them to consider everything. Isn't that right?
It depends what you're looking at. Certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture. That doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
You can't deny it. That's the line you were laughing about in your document.
You can't deny it. You have to accept what science tells you. I thought that was pretty good. Can attorney demeanor win or lose a case? Yes, it probably can. It shouldn't. I mean, it probably doesn't win or lose most cases, but I think it can really add to where the jury's kind of tracking with one side or the other. How's a 4-person chosen? Does Bev decide? I believe the answer to that is yes. What's the over-under for Brennan objecting during the defense's close? Got to be like at least 7. I would say under 7. Can AJ demand random jury trial or jury pick for Foreman? I think he can ask for it, but if that's how they do it in Massachusetts, then that's how they do it. Have you talked with any judges, current or retired? If so, can you share his or her opinions regarding this trial? Would love to talk to one. They all think it's absolutely insane. Every lawyer I've ever talked to about this case, I will just tell you, has told me this is incredible. It's insane. So much reasonable doubt. We shouldn't even be here. I have not talked to one. I did reach out to one that I like that seems online to be saying he thinks she's guilty or he thinks the Commonwealth proved it, but I've not gotten him to respond. And when I say I like him, I like some of the videos that he makes. I don't know him personally. Will AJ close? I believe the answer to that is going to be yes. If it goes to the jury Friday, how long would you expect deliberations to last? Would they go home for the weekend or go through the weekend? Love your recaps. I think they'll go home for the weekend. I think it's going to last multiple days, but I don't know. It's just a guess. Most of that's based on last trial. If it goes to deliberations, will they be deliberating sequestered over the weekend? I think the answer to that is no.
Physics, you can't deny it. You have to accept what science tells you.
Yeah, tonight, that's the line you were laughing about in the documentary, is one of your answers that you were all celebrating, isn't it?
Objection.
Isn't it?
The objection sustained.
I bet tell it right.
He's like, that's the line you guys were laughing about in the documentary. Objection sustained. They've already spoken about this. He already knows he's not supposed to ask this, and he still asks the question.
Sir, how to break that, man?
How did, oh, I don't know. There's no evidence of how it broke.
I have no further questions.
All right. You're all
All right. So that was the end of the last witness of this entire case. And they talk about Judson's PowerPoint. Sorry, they talk about Rentschler's PowerPoint. And the defense is like, why wouldn't it come in? Welcher's came in. The judge is like, well, it wasn't objected to. And this, folks, is why with lawyers and with every case, I get everything in writing. I make sure everything's on the record. I say, if we're going to let in Welcher's PowerPoint, they've got to let in Rentschler's. And of course, Hank Brennan is going back and not allowing it after so many PowerPoints have come in with inadmissible hearsay. These PowerPoints usually never come in. I've told you guys this. I was like, I've never had a PowerPoint come in that that an expert has used it as a demonstrative aid, and they're letting all these come in, which is crazy to me, but they're letting them come in. Until now, Brennan's going to object to this. I don't think it's that big of a deal, but Peter, really want your read on why the prosecution isn't recalling Welcher in rebuttal. So we're getting now to that point of the day, and let's listen to Hank Brennan discuss what he is or is not going to do on rebuttal.
And you want to put in evidence, the videos, just the videos, let me know that. And if need be, I'll hear you all on this tomorrow morning as well. Okay. All right. Is that it for today? Will we see everybody just tomorrow morning? What else do?
Mr. Leslie needs to, I didn't mean to interrupt.
After the defendant rests, we will not be calling any witness or not any further evidence.
Okay. All right.
That was shocking to me. That was really, really shocking to me. Are no rebuttal witnesses a white flag or more of a stop the bleeding thing? So the dog DNA stuff, honestly, and there's a lot of questions in here. I'm going to put them up in a second about Brennan promised to bring in the dog DNA. I don't remember him promising to put in the dog DNA, but I remember the judge saying he said if he was going to put it on, he was going to put on a rebuttal. And he did say he wanted to put on that rebuttal witness, but that is not why I remember the judge allowing it in with Russell. So he's like, I already got to testify to the dog DNA, no dog DNA, and it was pig DNA. Why would I want to bring a witness for them to cross-examine? Which again, blows that appellate issue up. I said I didn't think it was going to be an appellate issue if he called the witness in rebuttal because it eventually came in anyway, so it's a moot point. Now that he hasn't done that, I think he's created a huge appellate issue. But it is what it is, and that's the strategic decision he decided to make. I disagree with it, but it is what it is.
Right.
Oh, but then about Welcher, all the questions about why is he not calling Welcher, to me, the only thing I can think of is he thought it would do more harm than good. What are your thoughts on the prosecution not doing a rebuttal? What are your thoughts on the prosecution about not doing a rebuttal? I think it's crazy. You have the opportunity to call Welcher and ask him all these questions. You're not going to do it. You don't trust your expert. You don't think your expert's good. That's what it indicates to me. He knows Welcher was going to get smashed better than anything Welcher could add, and he's not even going to ask him. I'm really shocked about that. Honest, I am shocked, and I'm not because I agree with him. I don't think Welcher was going to do any good. I think it was going to be bad. What would happen if he said the FBI hired him, potentially a mistrial? You don't want to do that. I don't remember if there was anything else. Let's see.
Your Honor, it's late in the day. We would like to renew motion to require finding not just the disclosure of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would
I'd like to respond to that, Your Honor. The answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
okay, great. So
It's like, never mind. I don't have an argument if Brennan's not going to call anybody.
Second thing is we need to move in the 3 items of evidence, the documents.
All right, I want to jump ahead to when they talk about closing. I graded them. I mean, to me, it's a significant increase from a 5 to a 6.5. I think the prosecution was better this trial.
is in agreement, then I will let you have tomorrow without the jury. We'll have
So this is
our charge conference.
They're not going to be in court tomorrow. They're going to come back on Friday. We are still going to do a video talking tomorrow about the charge conference.
It's here in person. Then I'll give you the rest of the day to get your closing arguments ready. I'm imagining that you don't want to argue tomorrow morning at 9 o'clock. Is that fair?
That's fair.
Mr. Brennan, are you in agreement?
I'm in agreement. I'm not interested in arguing tomorrow.
Okay. All right. So we'll give you tomorrow. We'll have a charge conference tomorrow. I'm going to ask the court officers to call the jurors tonight as soon as possible. This is great that you did it. I was going to give you until 7 o'clock tonight, but if you're certain, then the court officers will call the jurors now and let them know they don't have to come in tomorrow. And then when they come in Friday morning at 9 o'clock, we'll do arguments and charge. Tomorrow morning will be the charge conference. Since we don't have jurors, do you all want to come in at 10 o'clock instead of 9 o'clock? Does that work for the Commonwealth as well?
Yes.
Okay. So I'll see everybody tomorrow morning at 10 for the charge conference. Do you have them now, Jim?
I do, Judge. And just for the record, YYY, ZZZ, AAAA, and BBBB are 223A through D. If you want to look.
In the same corresponding order. So you know what they are, Mr. Jackson, in order. Okay.
223.
223.
Thank you. My only other question, Your Honor, was regarding the parameters for the argument. Last year, we were relegated to 1 hour. I would ask 1 hour and a half.
You only asked for an hour and a half. I thought he was going to ask for much more because she's never going to give you what he asked for. And listen to how this turns out.
No, I got it. But yeah, you can go.
I'll ask for. I'll ask for an hour and a half for a final summation, given the case, the length of the case, the amount of evidence that's been adduced. I think that's a very summary. The court normally allows only an hour.
You might get an hour and 15 minutes out of me. Let me see it out an hour. Let me see. Yeah, you would
He's like, I should have asked for 2 hours. And he's right. She says he's not right, but I think he's right.
not have got an hour and a half by asking for 2 hours. Mr. Brennan, what are you looking for? Do you want the
I
same?
don't have a position. I'll take whatever the defense is.
Let me think about it. All right. So we will see.
And Brennan's like, I'll do whatever the defense does. All right. So that is it for our court watching today. I'm going to answer questions here on the way out. Make sure everybody hits the like button if you have not already. Why would Bev say no to 90 minutes for closing when it helps jurors? I mean, what's the difference between an hour and 15 and 90 minutes? You should have just said yes to that. When Lally didn't finish his closing because he ran out of time. I know. So dumb. So dumb. Do you think scaling it all back, make sure the main focus on the jury was he was not hit by a car rather than who killed him? Yes. I think that was a great idea. Why is Brennan able to ask questions about the witness that assume Karen hit John with the car? Well, he's trying to slip that in. He is allowed to ask hypothetical questions, but he's definitely pushing that. Do you think Hank's decision not to bring Welcher back has something to do with x-rays that suddenly appeared? It absolutely could. Wasn't it completely inappropriate that Hank Brennan brought up facts on evidence, nose glass, love watching, gives extra interest for my job as a court clerk? I believe those were facts in evidence because Karen Reed said, I got up there, I pulled the glass out of his nose and it was gushing blood. That makes it facts and evidence. She could be wrong, but it's still facts and evidence. Peter, with all the unethical behavior, do you worry about jury tampering by the Commonwealth? I think that would be a bridge further than what we've seen. Peter, what recourse does the defense have in closing to call out Hank Brennan's conduct? Objection, strike the argument, improper argument, and then appellate issues, mistrial potentially. A bit of a side note, but are attorneys ever worried about world events that come in during trial, like how much jurors reacted could bleed into the case? Absolutely, that's happened. That's absolutely happened. Like if some kind of attack happens and you have in a case dealing with that, absolutely. We've seen that happen in racially motivated cases. Can D make a motion regarding the bingo ball process in full open court and count them? To me, they can make a motion. Doesn't mean she has to do it though. John, reasonable doubt means doubt based on the evidence, not just any doubt. The evidence here, taillight in John O'Keefe's shirt, DNA on the car, seen in the vehicle reserve, clear, convincing, can't completely ignore this, in my opinion. So this shows me there are people on the jury that could still see it that way. I disagree with the way John is looking at it. He hasn't explained to me how the taillight made the scratches and how it made the scratches and shattered like it did and didn't break any bones or bust any ligaments or cause any bruises. It's pretty tough for me. Those are pretty big reasonable doubts. Jack, do you think the only reason the Commonwealth is doubling down on Karen's guilt, implication, police corruption might lead to other convictions? I can't tell you why. What if Hank manipulates or confuses the jury during closing? People say that's what lawyers do. So it depends on what your definition is of that. Join late. Sorry if I already discussed. Since Welcher's not back, in the defense bring up the discrepancy of the x-rays at closing? Absolutely. Hey, Pete, I missed something. What was the deal with the witness saying he was initially hired for the second trial by the Commonwealth? So the Commonwealth hired him on his... So no, he did not say that. He did not. He was hired for the second case for the defense. unless he didn't push a more forceful charge. He is going to do that, I think, at the charge conference, because she said that's when we're going to deal with it. Brennan isn't doing a rebuttal, or the judge already told him she wouldn't add the charge. Unless they did that at sidebar, I think he's going to be able to argue that at the charge conference. Calling Welcher is the worst idea. They have x-rays and evidence that Welcher didn't see. Nothing possibly good for him on a roto. Not that he didn't see, he said they didn't exist. This is a recorded young jury that still engages in late night social drinking. Who amongst them can relate to waking up after a night in question? They might have hit somebody with their vehicle. Hopefully not a lot of them. In my opinion, the lab tech isn't being called because she would testify DNA inhibitors were present. They definitely would have gotten some points on cross. Do you know if Massachusetts has model instructions that they have to follow unless situation calls for drafting them? I don't know, but I assume they have some kind of model instruction. Peter, do you think the defense will seek any type of discipline against the judge when this is over? No. I saw someone on Facebook claim that John O'Keefe's cousin who says she knows what happened. I thought the ME had to rule homicide before bringing charges. No, they do not, Lisa. They do not. It's nice if they do, and usually they do. And if they don't, it can create issues like happened here. Do you feel the evidence proven for counts? I do not feel like they have been proven. Brian B., how was the concert? We need to know. It ended up being a lot of fun. It was an incredibly late night. Voice is hurting a little bit. I'm incredibly tired. I don't know if you guys could tell during the video. I am wiped up so late and up so early. How was the concert? Hello. Did Jelly Roll put on a good show? I actually was shocked. I think I might have liked Jelly Roll more than Post Malone. Not to hate on Post Malone, but I really like the Jelly Roll part. I feel like I know more Jelly Roll songs too than I thought. Off topic, how was the concert, Tammy? Loved it. It was fun to get out with friends and with Wit. We enjoyed it. And thank God I didn't have to drive myself home, which was really nice. Jason, seems like if any case could be reversed for cumulative errors, this would be one. Apparently, cumulative error appeals are never reversed. Why? It is very rare to pick that one, but this one has some very big issues. Cumulative error is usually a bunch of little things. This one has some very large appellate issues. We have gone almost 2 hours. I have to leave. Hit the like button, subscribe. Love you all. Dinner with the family tonight. I'm actually a little bit late, so I got to run. Peace out. Love you guys. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.